going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. We made it to the end of yet another week. Let's have some fun tonight. Before we get into the video, I do have one major announcement. I hit my 1,000th video today. I didn't even know that was no idea that I was even close to that. Kind of blows my mind. But I got an email from YouTube saying congratulations on your 1,000th upload. It's like I don't know if that's a like yay or that's a wow. That just seems kind of sad. I've uploaded that many times. Anyways, we'll get off my soapbox for that one. So let's see tonight. What do we have? We have a bunch of stuff tonight. We're gonna start with the fake attorney from Judge Simpson. I know a couple of other channels already put it out, which is fine. I have the first part, not just part two that was today. I have the part from last week as well. So we're gonna watch them both together. So we're gonna have fun doing that, and then yeah, I got a bunch more clips as well. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
RNJ Group, or is that what it's supposed to be? $J Group Holdings versus Azar, is it Sadehi Stanfield and Gazal Stanfield?
Ready, Your Honor. Good morning. Anthony Mamina appearing on behalf of plaintiff RNJ Group Holdings, LLC.
You got either party here.
Good morning, Your Honor. My name is Azar Staffeld.
All right. And this is a termination?
Yes, post-lease term termination. We're not seeking to terminate for non-payment, Your Honor, just because the lease has in fact terminated.
The lease has expired.
Yes.
All right, ma'am, what's your
Yes.
position on that? They're seeking to terminate your tenancy, your lease has expired.
Good morning, Your Honor. This is not a landlord-tenant case, Your Honor. This is the owner of record versus the real owners of property, which are us.
Pardon?
And yeah, we are the real owners of the property. This property was wrongfully foreclosed. This property, I petitioned for a stay because our case against Wells Fargo is pending in federal court. And we want Your Honor to issue the stay because we also notified Mr. Mamina that is in fact them that are violating their contract because this was not a tenancy. This was a lease with option to buy. We have been notifying them that we are ready to purchase the property since it has been 2 liens gone on the property. Our mortgage is ready, our down payment is ready, and then they cannot remove the liens, Your Honor. And the liens are one from Ann Arbor Township. So unless R&J Group remove the lien, we cannot proceed with our mortgage to purchase the property. And this was our plan B to begin with. Our plan A is our case pending in federal court for wrongful foreclosure. So I want to petition for a stay before this honorable court till the.
Well, I'm not going to grant a stay if that's what you're asking for. However, you say there's an action that's pending in federal court?
Correct.
Counsel, you know anything about that?
No, as a matter of fact, I do know something about that, Your Honor. What they're claiming is that there was a foreclosure started by Wells Fargo and Wells Fargo failed to Honor, they're claiming, we don't believe that's the case, and the pleadings bear that out, failed to do the necessary post-default workout as required by some of the COVID statutes relating to defaults and mortgage defaults. It has nothing to do with us. We are not a party to that suit. We haven't been served with it. As a matter of fact, I've been advised by your office or the clerk in the court that Ms. Staffeld, who incidentally is a Juris Doctor.
Yeah, this is part one. This part happened last week. So when the part happened today, I wouldn't grab this to make sure they were both together. But I have the next one that happened today right after this. But the attorney's just now saying that she's an attorney. You know what? I paused at the absolute wrong time, so I'm actually going to rewind it about 10 seconds.
We haven't been served with it. As a matter of fact, I've been advised by your office or the clerk in the court that Ms. Staffeld, who incidentally is a Juris Doctorate, as I'm told by her, and a PhD and other advanced degrees. So she's not uninformed here, Your Honor. This is in fact a lease with an option to purchase. That's it. It is what it is, and I've provided a copy. It's not. She does not own the property. My client is the record owner of the property. We agreed to lease it back to her. She was the former owner. She lost it in the foreclosure, which is the subject of the federal action that involves Wells Fargo, not my client in any regard.
Well, hold on a second. So,
Go get the Wells Fargo
but,
from
but
the bank.
hold on. So that I'm trying to follow this. Wells Fargo foreclosed on the defendants in this case.
Correct.
Your client is the purchaser from that foreclosure,
Yes, Your Honor.
and she's challenging the foreclosure in federal court. All right, here's what I'm going to do, folks. I'm going to adjourn this out 1 week to the 28th, 2025 at 1 p.m. At 3 p.m., excuse me. Ma'am, you are to file an answer to this complaint along with information regarding that the federal lawsuit. I understand that plaintiffs in this case aren't a party to that, but I'd like to at least take a look at that before issuing any ruling on this case. So you'll need to file an answer. It should include not only references to that federal lawsuit, but I'd like a copy of the complaint and answer also on that.
Absolutely, Your Honor.
All right.
Thank you, Your Honor.
Can you extend that 1 week to 2 weeks?
Do you have any objection to that, counsel?
I certainly do, Your Honor, but of course.
Okay, then
I'll
do what the state. We'll go 1 week out, folks.
Thank you so much.
28th.
Your Honor.
3 p.m.
Thank you,
Thank
Judge.
you.
Have a nice day.
All right, and now we fast forward till today. This one's good. I don't know why I kept that first one. It was just in my random live folder. If court was slow, I was gonna throw that in there. It's like, it's okay. It's kind of interesting. She's a lawyer and a doctor. Apparently, she's not a lawyer. I want to know if she's actually a doctor. Let's go.
Our $J Group Holdings versus Azar Segdahi Safel. So, what was that?
Ready, Your Honor.
Good afternoon, Your Honor.
Hey, welcome, Queen
Where are
Olive.
we
Good to
on
see you.
this?
May I pass to the bailiff to hand this to the,
What is it?
this is the petition for joinder before federal court we filed, Your Honor.
The petition for joinder?
Yes. We amended the complaint and we added R&J holding to our federal complaint in U.S. court.
No. Have you seen that?
I have not, Your Honor.
Well, you can't just give me things and expect the court to take them without showing opposing counsel.
Okay, I have a copy for him. He refused to accept.
Your Honor, she hasn't tendered it to me. Also, for what it's worth, yesterday at about 11 o'clock in the morning, the defendant served upon my office a ream of pleadings, responses, motions to stay, motions to dismiss, and so on. And I did my best
For what case? For this
for
one?
this case. We're not a part of that federal case, and she is doing the classic attempting to turn this into a federal case, when in fact, it's just a summary proceedings action, Your Honor.
Absolutely not, sir.
And I did
you
also give her copies of everything I filed by overnight.
Is that really a classic maneuver? I mean, that's kind of a sovereign citizen maneuver, isn't it? To try to turn something small into a federal case. Just saying. Not saying she's a South Sit, but we're gonna find out a little bit more during part 3. Hey, Legal Fiction, thank you so much for the 5 gifted memberships. That is very generous of you. Welcome to the 5 new members. Thank you so much, Legal Fiction.
Mail and today. I handed it to her a while ago and she gave it back to me. I'm not going to fight over it, but they served me with a series of motions. I had to
I
respond.
don't have any motions.
Well,
Yes, Your Honor, the package in front of you has a motion to dismiss, has petition for a stay, has answer to the complaint. and
Okay,
has a
you filed
counter
these
complaint.
today? Yeah.
No,
today.
we filed it yesterday, Your Honor. You only gave us a week to answer. Remember, Your Honor?
Your Honor, you gave her.
Oh, ma'am, I remember everything I do. Do not try to address me that way. I will have a memory that will throw you in circles. So don't come at me like that. Because if you come at me like that, you're going to get hurt.
I respect.
Counsel, what were you saying?
Your Honor, I was saying that as I recall, and I wouldn't challenge your memory, you may as well, when we were appeared and she asked for the opportunity to present some reference to this federal case, you
Yes.
said, we're going to adjourn this till next Friday at 3, and you can deliver to me a copy of that federal case so that I can look at it.
Right.
Not file a whole host of other pleadings and other matters at the last minute. I mean, that was tough for me to handle, but I got it out, Judge.
Well,
A copy of federal pleadings is part of that package that was hand delivered to this gentleman and to the court, Your Honor.
We have nothing to do with that federal case, Your Honor, at this point.
Now,
She
you
has a
can-
case against Wells Fargo, who was a prior mortgagee in the case. We have nothing to do with it whatsoever. We're the deed holder of the property.
there's also been a parties added.
42. 42 was always the answer for how many. Anything less than that, it's not acceptable. Anything more than that is way too many.
They counterclaimed against us yesterday at 11 o'clock in the morning and filed several motions. No parties have been added to this case, but she says she wants to add us to that federal case, and I
Well,
encourage.
the caption is changed.
Correct.
You can't just change the caption.
Well, we haven't been served, and if I got the document.
Counsel, I get it. I'm just saying, this caption that I have on your documents is not the caption of this case.
I'm sorry.
The caption here, who is Carl Stafford?
Carl Stafford is here. He's my.
I don't care if he's here. He wasn't a party to this case, was he?
No,
It says all residents of the house, and he's the resident of the house.
You can't just change the caption.
What do you suggest I do, Your Honor?
You don't want to hear that. I suggest maybe you get an attorney because I just don't.
she is an attorney, Your Honor.
Well, that's even more alarming. Um, I don't even know what to do with this because the caption has changed, right?
Yes.
You served motions and apparently there's a counter complaint that the other side or whoever was supposed to add doesn't have an opportunity to answer. I don't even know if there's been a summons issued for these other parties.
Yes, there has.
Are you an attorney?
I'm not a bar license holder attorney. I went to law school.
Yeah, so did everyone in my chat. We all went to law school, the law school of YouTube. None of us even claimed to be an attorney. So the answer was no. You're not an attorney. Just say no. No, just say no.
Counsel, you filed an amended complaint, correct?
I did, Your Honor.
All right.
We have not received that.
I gave it to her.
No, we have not received,
I
sir.
gave you the packet and you gave it back to me.
When was that, sir?
Just now, I gave it to
You
your
gave it
husband.
to
You
me
two
now.
want to have your own darn conversation. You can do it outside. You don't need me here.
I
I'm not going to be a third wheel on a date in my courtroom.
I'm sorry, Your Honor, very sorry. I did give her all of those pleadings and the amended complaint in a white envelope, which she
Did he-
handed back.
Did he give you an envelope and then you give it back?
Yes, because
Why?
because I tried to give him the joinder and he gave it back.
She never handed it
This is
anything.
like,
to me.
this is like kindergarten. I'm going to accept the first amended complaint, counsel. You can serve it on her in whatever way you wish in terms of either you can do it by email or you can serve it by first class mail. If she won't take it, she won't take it. What you filed, which starts out entitled plaintiff's defendant's answer to the counter, you're gonna have to refile this. I'm striking this pleading. You can't just change a caption. Well, guess we're done. And so I'll give you a week to get that out. I realize it delays the proceedings, but I don't think I can do anything else. Because I don't know why these parties are running around in this case that you just added to this as the petition to stay is filed on this is crazy. You're gonna have to start over. I'm striking all of that you
Okay.
filed. And you're gonna have to just do it right. I'll take yours, you serve it, they'll have to answer, and then we'll go from there. I don't know that putting it out to next week is gonna do us any good, so I'm gonna put it out to the 14th.
Thank you, Your Honor. I would ask the court if it may. She hasn't paid rent. They haven't paid rent since November. The rent for November, December, and January is $5,000 a month. And the rent for February and March is $5,500 a month. I would ask that you ask them to escrow.
What is the current monthly amount of rent?
It's, there's a holdover provision, but we'll accept the normal rent, Your Honor.
About 5,000?
5,000 for.
I'm gonna order escrow.
Escrow, we would pay it in escrow, Your Honor, but not to them, because they have to sell the property to us.
I'm gonna order that you pay escrow to the court in the amount of $5,000. I'm not gonna do a proration back to the original. You'll start that March 1st. It needs to be paid within 7 days of the date of my order, and then needs to be paid each month while this matter is pending. Do you understand that?
Yes, Your Honor.
Please
Thank you, Your
prepare an
Honor.
Order to that effect. I will
So
adjourn this.
February rent and March rent.
I can only have March rent.
March.
I could prorate a day February, but I'm
That's
not.
not necessary. We'll accept the,
March 14, 2025 at 1 p.m. I feel a cold coming. 1 p.m.
Your Honor. Have a nice weekend.
Yeah, I will now. All right, now give it. Yeah, give it, because, Ann,
Can I take it?
can you what?
Could we submit the joinder or no?
You may, if it is in proper form, submit it anything that you like, but not to me.
Okay,
You can file it with the clerk's office once the file gets up there.
by all means.
Just don't. Just don't. Just
Are we dismissed, Your Honor?
bye. Yes.
Thanks, Judge.
All right, that was fun. That was a good way to start out the night, wasn't it? I think so. Yeah, I have no I have no idea what's coming next. No idea. Yeah, that lady's not an attorney. Yeah, no. Somehow she talked the plaintiff's attorney or the landlord's attorney into thinking she's an attorney. Probably because she just gave him a bunch of documents. He's like, oh, I'm not reading all this. Like, yeah, I do. All right, let's just move on. Deep breaths, deep breaths. Okay, next case. Let's go.
Number 16, case number 2302947, DP Lane versus Banks.
Your name? Yeah.
Hello? Yes.
Thanks. Good morning.
Yes. How you doing?
I'm fine. How are you?
I don't know my phone.
Good. Good morning to you too.
And Aurora, is that Aurora Lane joins us?
I turned my
Hi.
Bluetooth off.
There you go. Can you hear me? Where are we walking to, Miss Lane?
I get off your Wi-Fi.
There you go. Can you hear me?
Our Wi-Fi just was messing my phone up. Can you hear us, Miss Lane? Hold on 1 second.
It's always off to words. You know it's gonna go
I can
well
hear you
when.
now.
All right, I'm stumbling over here. You know it's gonna go well when it starts off with one of the parties telling the court to hold on 1 second. Yeah, let's go.
Can you hear me now?
Yeah, I can hear you.
Okay, find a place to land, will you? You good?
Yeah.
Okay, because if you keep moving, you're gonna cut the camera out. Okay? And I don't want that to happen. So, this is Mr. Banks's motion. He classifies it as a motion for custody. Did you get a copy of that, Ms. Lane?
Yes, actually, we had another issue with that because I guess he's supposed to serve me a paper, but instead of him just knocking on the door, Miss Banks entered my home, he legally trespassed, and he said he has a video. I have messages from him and his mother coming to my home and giving me my paper.
Okay. Did you get the? My only question was, did you get a copy of the motion?
Yeah, but I didn't not even willingly. I didn't know nothing about this. He just came in the house and gave me that paper, walked in my home. I didn't know. Is that how I'm supposed to get it? I don't know.
Well, I mean, how you're supposed to get it is really based on how the parties are behaving with one another. If parties, I've had some people who get along with their former girlfriend, spouse, that text it to them. I have some that drop it off. I have some that email it. I mean, it's just.
Okay. You could have just texted. I didn't know. Yeah, that was fine.
I mean, it's just. I'm just what my goal is in asking that is to make sure that you got a copy of this in.
Oh yeah, I got it. And I read it.
Okay, that's what I want to make sure. All right. So, Mr. Banks, anything you want to add to what I've already read before I turn things over to Miss Lane?
Yeah, I just want to say one thing. Anything that she say like about me is not about me. It's about like my kids, custody of my kids. I couldn't staple the paper, but I got papers from both of my kids' doctors. They stating that they never seen the mom, the biological mom. I got papers from Port City Pediatrics that me and my mom, the only person that take my kids to the doctor. My daughter, 2 years old, she was going through early on program, as in she couldn't walk. She finished the program here in Muskegon. Like, and my son, he go to school here Monday through Thursday. Been doing it for the last 3 years, and now just like all of a sudden when she get mad, it's like right now he's 20 days he hasn't been at school. Like, so that's all I got to say.
How old are they?
My son is 5 years old.
And your other child?
She's 2 years old.
Okay, so I don't know if legally either one needs to be in school, but I appreciate what you're telling me. Well, what's going on, Miss Lane?
First off, the couldn't walk. You see, he never mentioned my daughter. He never been around. I actually, where he stay now, I actually have messages between me and his current girlfriend that he have a baby with now, saying that they was fine with my son, but she said I left Floyd Banks. We separated when I was pregnant. She has always made it known that she does not want my daughter around. I literally had messages coming out her own mouth saying I do not want that baby around me for the first couple months when that baby born. And who gonna do something about it? She got what she wanted. He's not on the birth certificate. About the couldn't walk, she has Cesare positive, and anybody you know that's a medical condition that you find out at birth, he wouldn't know that because he was not allowed to be around his daughter. He also doesn't get her that much because he said he can't leave her at the house where he stays because she hollers and screams when she's left alone with the girl. So my son, me and him always had a great relationship with our son. Me and him was together for 7 years. Me and him separated. And so he wanted to take my son and spend more time with him. I let him. Also, I have severe anxiety, so I don't drive at all. I have never learned how to drive, and I'm 24. So as far as the doctor's appointments, yes, he takes him to the doctor. We don't. I'm not going to, and he stays in Muskegon. Yes, I appreciate him from that. I literally cannot drive. My anxiety stopped me from doing a lot in life. So yes, I do appreciate him. They have never seen me because the doctor's in Muskegon. We left the doctor in Muskegon because that's where he stays. And it was more convenient for him to take him there. It was never like I just didn't participate in my kids' life. Yes, he just only wanted my son. He never wanted nothing to do with my baby. So that's the issue. I have multiple messages like, you have to get her more. You have to do this. Like with my son, we had a great parent relationship. I let him go to school with him. It was great. Like, but my issue is never with him and my son. He can get his son. My issue is with my daughter because you don't get her. You just forgets about her. Even your current spouse don't even like your daughter. And she has told me this in the messages. She has said, I do not want that baby around me. You're not even on her birth certificate. You're not on her birth certificate.
Hey, wait a minute. Hang on. This isn't the Jerry Springer show, people. You don't just pipe up whenever you want. All right. Now, I have a question, Mr. Banks.
Yes.
It looks like there was a judgment of paternity in October 27 of 2023. I'm assuming that was for both of these children. Is that correct?
Yes, sir, and that's correct. And she's been applying with it. She's like, if you can ask the judge when we went to court, the person that talked to us, she was I'm a good father. I take care of my kids. Like I just told you, my son go to school here, 5 years old. He's been doing it for 3 years. My daughter, my kid.
Yeah, I want to clip that and put it next to Judge Slavin saying it. I didn't, we get a couple other judges to say it. We'll have a Jerry Springer show little clip. I like that idea.
kids go to the doctor, sir. The doctor never seen their mother. Never. I got every document. I don't even got to talk.
You told me all that. I was just interested in making sure that that you received the proper designation. Because if you are not the legal father or haven't been declared the legal father of one or both of those children, then there's certain things I can't do. But it sounds like that since there was a judgment of paternity in 2023, I'm assuming that took care of both of the children and that you have been established as the legal father.
Yes, I am the legal father.
I cannot at all resolve this on a Friday morning because everybody's got a lot to say about this case. I know Mr. Lane does, I know Mr. Banks does, and who's ever around you guys right now does as well, because I have heard people on the other end.
Right.
So I know everybody's got their own.
Yeah, because we was thinking this court wasn't going to be on Zoom. That's why we came with all the documents and we wasn't thinking it's going to be on Zoom. It came.
Mine are always on Zoom. Everything I do is on Zoom. So what I'm going to have to do is I'm going to have to send it for a complete and full investigation, which I'm going to do. The investigation will be custody support parenting time. Their friend of the court is going to meet with both of you, hopefully together, but if that can't happen, they're going to do it separate. And then they're going to have you fill out questionnaires. Then they're going to ask, talk to people who you tell them to talk to, check out doctors, that kind of thing. And then at the end of the day, they're going to make a recommendation to me based on the 12 best interest factors found in Michigan Compiled Law 722.23. And once they get the recommendation, they'll send it to both of you. You might not get everything you want in that recommendation, but that would be the last time that you would be able to somewhat control what goes on with your children. Because after that, if a party objects to it, then we have to have a trial. And then it gets complicated and expensive. And then I have to make the decision after hearing testimony and evidence from people. And then I've never had anybody completely happy with everything I've done. So, but I'm going to get this process started now, well, within the next week or so. Mr. Banks, are you currently working?
No, I'm not right now. I was just working, but like it's so hard because of like child support, or I pay child support and send money. Like I got proof for everything. Like I send money to her physically, or her mom, or child support, or I actually buy the clothing for my kids. Like,
but how is not working gonna?
Because I got a whole family of my own over here. I pay rent of my own over here, and while I'm paying rent over here, I continue to take care of my kids over there.
Right, but you're not understanding what I'm saying. If you're able to pay rent over there, how are you doing that if you don't have a job?
Sir, I'm barely doing that, sir. I'm barely getting by. My mom is helping me, sir. I filed papers for everything, for the child support, everything. Ariella will see. I just was working a year until they was pulling so much money out that I couldn't afford to keep up with my rent and help her out.
Okay. That's all right. Miss Lane, are you currently working?
Yes, I am. And I also want to add, he been on the new child support case was when after my daughter was born, the new child support case was established February 2023 to 2023 to now. He has paid $2,000 in child support. That's $55 a month.
But let's not forget
That's how much I get. Also, I have messages, multiple messages of Floyd Banks telling me, why do I have to help? Why do I have to help you with you over there if I buy them stuff?
I found that out the hard way, peeps. Yeah, absolutely. Don't give it straight to her. You're not getting any credit for that.
When I'm over here, he have told me at that multiple times.
Stop. Okay. This is why we don't have these hearings like this. So you can tell all these things to the friend of the court investigator. So the fees for this investigation is $300, but I'm going to waive it for both of you. So now you're on my dime. So there should be no excuse of why people can't get this case done. And I want to make sure that you both understand one thing. Number one, the friend of the court is going to be sending you.
This is when Cheshire Cat found out that peeing in the pool and peeing into the pool are two completely different things. He's still embarrassed by that.
Stuff in the mail rather quickly. You got to make sure that the friend of the court at 82 Ionia has all your correct contact information, because they don't forward mail. The second thing you have to do is make sure this court has all your current contact information, because they don't forward mail. And if you have any doubt whatsoever in your mind, if you're 99% sure you're good, come down anyway. Take a visit down to 180 Ottawa, 82 Ionia, confirm that they have all this stuff, because things are going to be happening rather rapidly from this point on. I'm going to sign the order sending it there today. So you should be hearing from them shortly. But you're all set with me, both of you, and we'll see if we can get it figured out for you. That's all I can tell you. We'll give it a shot. You're all set. Thanks. Have a good weekend.
You too. You too.
Both those parents were aggravating me. This is why I don't do family court. I feel for dad in this one, kinda. I think mom's a little out there, but yeah, I mean, some of the comments that mom made are kind of worrisome. That, you know what, I'm not going to do it. I'm not going to go down this road. Not going to. Let's just move on before I say something that I'm going to regret. Let's go.
Let's see who this is.
Judge
I
Middleton.
think it's the manager.
Good morning. This is Matt Davidson for Larry White against Taylor.
All right. You can't get your system to work again?
I'm on a different computer and I'm trying right now to join, but it didn't behave right the first time, so I had to restart my computer. But yes, that's the answer.
All right.
Yeah, I wanted to comment on that, and I stopped myself from it. But then you said something. Yeah, see, that's what bothered me. He wants more time with his son, the son that, like, he knows. The mom said that they split up while she was pregnant with the daughter, and the dad doesn't seem to want anything to do with her. And unfortunately, she has cerebral palsy, so she needs a lot of support. And it sounds like dad is like, oh, I want more time with my son. You got two kids, man. You got two kids. This is why kids shouldn't have kids. And yeah, they're not legally kids, but they're still kids. Not a good decision for them to have kids.
Miss Taylor, can you hear me?
Oh, yes, I can.
I really don't like doing these by telephone only. Particularly, I don't like doing them
I'm
with
sorry.
the attorneys.
I'm new to all this stuff, so.
Yes. All right. Often people will just come in, but you're here, and well, you're not doing any worse than the plaintiff is. They're here only by telephone either. But let me tell you what your rights are as a tenant in a landlord-tenant case. This is a demand for non-payment of rent. Your rent is pretty substantial. It's $1,000 a month, which is a lot for a 615 square foot, 1 bedroom, 1 bath apartment in Constant and White Pigeon, but that seems to be the current going rate. I'm just shocked, but anyway. You have the right to hire an attorney. If you cannot pay for one, the court must give you information about legal aid, and legal aid is actually here with us on the feed. Megan Bauer from legal aid is here watching the proceeding. You have a right to have the matter heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first appearance or make the demand in writing within 5 days. Pay the $50 jury demand fee unless the judge waives your requirement to pay the fee for your inability to pay. If your landlord has asked you to be evicted from residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a homeless veterans program if you are a veteran. And I did send somebody down there today to try to get some help. You do not need a judgment against you to get help from the places listed above. A copy of the summons and complaint are sufficient. You may be able to reach an agreement with the landlord by going through community dispute resolution, also known as mediation. If both parties are agreeable, the court can help set that up. And finally, if you do reach an agreement with the landlord, that means the case would be dismissed. We could file, Mr. Davidson would file a conditional order of dismissal. White v. Taylor. Miss Taylor, are you still there?
Yes, I'm planning on getting out next weekend.
All right.
I mean, there for the reason of the rent anyway, there was an incident that had happened back in January of 2024 that literally took me out of commission. Okay. It was at no fault of my own, mind you. At this point,
January of 24, 25, because
24, January of 24. Yeah. I don't know how much I can honestly say, but I feel
hold
that.
on a minute. The rent is $13,000 in arrears. So apparently no rent has been paid for about a year or more. Mr. Davidson, what's the current arrearage?
That I'm not positive, Your Honor, but it would fit with the, I'm just trying to see real quick in the complaint if another rent has come due. Yeah, the total rent on 10, so we can add $1,000 pretty much for 4 months.
All right, well, this isn't the greatest. All right, rent paid through October 1st. So we had October, November, December, January, and February, which would be 5 additional months at $1,000 a month. So the amount due is $18,130. Court costs.
18,000 in rent. So let's break this down. 18,000, 1,000 a month. She hasn't paid for a year and a half. Man, I don't know why they waited so long to evict her. I'm just saying.
Are 95, 55, 5120 service fee, $75 statutory attorney fee.
Your Honor, if I could explain a little bit.
Yes.
Okay. In the incident that happened in January, like I said, was no fault of my own. After Mr. White had received a letter in the mail, okay, then it turned into, I honestly feel that this is in retaliation of the letter that he did receive. Okay. Ever since then, he makes comments to me. All sorts of stuff.
Well, just a minute. Have you not paid any rent in more than a year?
I wasn't able to work because of the incident that had happened in January.
All right. Well, so nonetheless, you haven't paid it. You owe $18,000 in unpaid rent. $18,311.20.
Okay, like I said, I wasn't able to work. I was in a wheelchair.
I understand.
Up until
so
June,
the fact that you're not
June or
able to
July.
pay the rent isn't a defense that you haven't paid the rent. And this is a lot of rent for what looks like a little converted garage. But nonetheless, you can't just stay there indefinitely without paying any rent. So the law requires that I adjourn this 1 week.
I get what you're saying, but like I said, I had no way of any income. When I did call places to try and help me with the rent, they only go up to $750, not $1,000. Okay.
Yes.
I have over $12,000 in medical expenses alone from the incident that had happened in January. Like I said, which was no fault of my own. I was in a wheelchair up until July, and then I ended up having to use a walker. And my whole life has been turned upside down by this incident in January. I've lost my job of 2 years. I've lost my vehicle. There's not too much more that anybody can actually take from me. In December, Mr. White, he has turned off my heat. I've been sitting here. I've gone through all the cold spells that we have had with space heaters.
All right, well, let's talk about that. The next date is March 7th at 2:10. And I don't want everybody by telephone. If you can't connect by Zoom, I want you to be here live.
Your Honor, March 7th at which time?
2:10. Does that work for you?
Yes. Thanks,
All right,
Sharon.
now, Ms. Taylor,
Yes.
what you're describing
I completely lost track of time. I was just reading the comments, watching the video, having a good time, and then boom. I don't know how I just completely forgot about this tonight. Usually it's on my mind, from the time I start till the time it happens. Maybe I was just blindly ignorant that it wasn't going to happen tonight. I don't know. How are you guys doing? How are you guys doing tonight? I don't know. Yeah, this lady's fun, right? I couldn't work, Your Honor. That means I don't have to pay rent. Okay. 18,000. The landlord's beyond fear. It completely kicked me out tonight. It's gonna be one of those kind of nights. Sorry, guys. At least I'm smart now and I take the timestamp of the video, so I know where we lost it at. I appreciate you guys being patient. You guys are awesome. I do appreciate it. Let's see. No, that's close enough. About 6 seconds behind. Do we want to try it now? Do we want to try it to hope it works, or is it just gonna fall down again? Oh, good point. This oh, that's so sad that I'm excited for daylight savings time because it's not gonna happen. That means this isn't gonna happen in the middle of my stream. Ah. Anyways, all right, let's try. It's saying my internet's good. All right, you know what? Let's go.
A violation of the lockout law. Your landlord can't turn off your heat. It's against the law. So I don't know if they actually shut off the heat or the propane ran out or what happened.
No, I'm sorry. It's a boiler system. Okay. And December 15th, I had let him know. So, I mean, even if something to me was wrong with the boiler system itself, he's literally had plenty of time to get it fixed. I got sick over that. So then I had there's another medical expense that I've had to have.
All right, well, let's talk about this. So have you made any effort to try to find a place to go?
I do now. Yes. Yes. Like I said, you know, the first time that he told me that he wanted me out, I was still in a wheelchair. I mean, there's not too much that I can do when I'm in a wheelchair. You know what I mean? And like I said, regardless of what he feels that I owe him, I've lost so much more than what he feels that I owe him in rent. Literally.
All right.
I'm on disability now.
All right, stop.
You know,
he's got a payment to make. You've lived there for 18 months without paying any rent. It's amazing he went as long as he did without asking to collect the rent. So I understand you're in dire straits, but if you had done this earlier, I guess you could have sought some assistance earlier. They're not going to pay $18,000 of arrearage. And you're right, $1,000 is expensive rent for St. Joe County, but that's what the market is going to. I looked at this place and it's quite small. At any rate, when you say you're working on finding a place to go, tell me about that.
Well, I mean, like I said, I mean, I tried reaching out for help, but like I said, nobody was going to help me at $1,000 a month. I had talked to Mr. White and tried to tell him, you know, that, you know, they only go up to $750, and he just didn't care. I mean, I could have got a hold of MDHS, you know, when I got served, but he waited for how long to actually serve me papers. You know what I mean? So, like I said, I didn't have any place to go, and now I'm going to move in with my son. Okay. There's nothing else I can do. You know, like I said, I'm on disability because of all this, because of the incident that happened in January.
Okay.
I went from working 74 hours a week to nothing.
Yes, you're right. It's life altering. All right. Well, I'm continuing this to March 7th at 2:10 p.m. via Zoom or live. I can't see you. I don't know who I'm really talking to. I recognize Mr. Davidson's voice, but it's not ideal to have plaintiff's counsel appeal by telephone either. But anyway,
I apologize,
you're going to get 10 additional days from that day to move, which would be March 17th. So essentially, you've got until March 17th to move, or you could be subject to being evicted. At this point, they're not asking
She doesn't go into it. She didn't say. She just mentioned it a couple times. And the way that she was acting, kind of entitled to stay there for free. I wonder if something happened on the property. That's what I thought when I first watched it. I was waiting for her to say, I slipped on ice walking out of this rehab garage I live in, but she never went into it, so I don't know.
For any money, they're simply asking you to move. Even though this rent is high, I suspect they have a waiting list of people that he could rent it to. So, all right, let's revisit this next Friday at 2:10. Do you have any questions,
No.
Ms. Taylor?
No, like I said, I'll be out next weekend on the 8th.
All right,
The
if
8th or
you
9th.
are
Yeah.
out, then you turn in the keys and give your forwarding address in writing within 4 days. And we don't even need a hand to have a hearing. But next weekend will be after the 7th. So, all right. Very good. Thank you.
Okay, no problem. Thank you, sir.
All right.
And thank you, Your Honor. My apology.
All right.
Yeah, we played that case last night. That was part of last night's live. Let's see. I think we have two more clips. Hold on, let me see. I know what the last clip of the night is. Oh man. Oh, I had a little editing mistake. It looked like it was only for a second. All right. I kept this clip in here for one big reason. And when it happens, I am going to blow up because I do not like what happened in this to the defendant. Now, the defendant kind of deserves a lot of things the judge is saying to him, but there is one specific thing that that really got me mad, and I think you guys are going to agree with me. This is a little bit of a longer hearing. I did actually go through and try to cut it down, but it's just, I don't know. I just wanted to play you guys the entire clip so you had all the context of what was going on. Therefore, when I get heated here in about 15 minutes, you'll understand why. Okay, let's go.
Okay, the court is on the record in State of Ohio versus.
I am so sorry, guys. I want to catch up with the super chats before the next. You guys all sent super chats while I was frozen. The only super chat that I actually saw was Legal Fiction saying I missed a super chat. And that's when I looked. I'm like, oh, I do have more. So thank you so much, Legal Fiction. Cheshire Cat. Shh. You're going to jinx it. Let me go find some wires. Thank you. Yeah, thank you, Cheshire Cat. I'm guessing you found the wires. Legal Fiction, I think the video is frozen every night. Thank you. I appreciate it, Legal Fiction. Sparkle Poops. So other than the shooting, how'd you enjoy the play, Miss Lincoln? Thank you, Sparkle Poops. I appreciate it. And then Legal Fiction saying I missed the super chat, which I in fact did. Thank you so much, Legal Fiction. I appreciate it. All right. Erica, this is in Conneaut, Ohio. The judge's name it's not a normal name, and I don't even remember what it even sounds like. But it's in Ohio. It's Conneaut. All right, let's go. For those of you who don't know, Conneaut's kind of close to Cleveland.
24
I think.
CRB.
Pretty sure it's in the Cleveland
City
area.
of Conneaut versus Lucas Vickery. 24 CRB 268. 24 CRB 267. 24 CRB 251. 24 CRB 213. All of these cases are set for a preliminary revocation hearing today. Probation violation complaints were filed against Mr. Vickery in all of these cases. On January 8th of 2025, warrants were issued for his arrest, and Mr. Vickery was arrested on those outstanding warrants on February 26, 2025. He is appearing at this hearing by way of video from the Conneaut City Jail. Also present is probation officer Sean Benoit, who is appearing on video. He's in the courtroom. Mr. Vickery, several probation violation complaints. They're all the same complaint, but they've been filed in each of these cases. Have you received copies of those complaints?
Yes, sir.
Okay, I'm going to read you your rights. So please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the complaints filed against you. You also have a right to know the potential penalties that could be imposed. In 24 CRB 348, this is where you were recently convicted on December 10th of 2024 of receiving stolen property. The probation violation complaint, and the complaints all allege that you failed to maintain contact with adult probation, failed to comply with recommended treatment through community counseling center.
Yeah, is it Iaroki? Is that what it is? Iaroki. I think that's it. I don't think it's Iarochi. I think it's Iaroki, which is a cool name. I like it. Yeah, I will butcher that every time.
Ordered. But anyways, if you're convicted of violating your probation in this case, I could impose up to 165 days in jail. I could extend your probation from what was originally 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. Do you understand the maximum penalties you face?
The defendant's in jail, so he's actually not there. He's on the TV screen that we can't see. Yeah, this courtroom has a weird setup, though.
If convicted of violating your probation in that case?
Yes.
The next case, 24 CRB 268, you've been convicted of 2 counts of theft. If you're found to have violated your probation in that case, and those sentences were ordered to run consecutive, I could impose up to 342 days of jail, 171 days on each of those counts of theft, so a total of 342 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So when I say 342 days, that would be in addition to the 165 days that you face on the previous case, receiving stolen property case. So in total, I could sentence you to up to 507 days in jail if violating your probation in both of those cases. So do you understand that?
Yes, sir.
In 24 CRB 267, you were also convicted of theft, another count of theft. If you're found to have violated your probation in that case, I could impose up to 171 days. That would, even though I originally ordered those consecutive, unfortunately for me, I cannot impose more than 540 days of jail. So that would have to be concurrent to any sentence. So that would run at the same time of the 507 days that I've indicated the maximum time you could serve. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So do you understand the consequences you face in that case?
Yes, sir.
In 24 CRB 251, you were convicted on August 15th of 2024 of criminal trespass. If you're found to have violated your community control in that case, I could impose up to 29 days in jail to run at the same time or concurrent with the other jail sentences. I could extend your 1 year of supervised probation from 1 year up to 5 years, and or I could impose more restrictive community control sanctions. Do you understand the maximum potential consequences you face on that case?
Yes, sir.
Finally, in 24 CRB 213, you were convicted of littering, a first-degree misdemeanor, on September 9th, 2024. If you're found to have violated your probation in that case, I could impose up to 171 days in jail. Again, that would run concurrent or at the same time of your other jail sentences. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So do you understand the maximum consequences you face on that case?
Yes, sir.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a final revocation hearing. That's another hearing. At that final revocation hearing, you would have a right to cross-examine witnesses and confront evidence presented against you. You would have a right to testify or not to testify without any negative connotation. You would have a right to subpoena witnesses to testify on your behalf. You would have a right to be proven guilty by a preponderance of the evidence. All of those are hearing rights you would have at that final revocation hearing. You also have a right to an attorney, to have an attorney represent and advise you in this case. And because you are facing a possible jail consequence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply, because I believe in all of these cases you were never represented by counsel, the public defender's office in particular. You also have a right to a continuance of this preliminary revocation hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of violating the terms of your probation in any of these cases, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to any of these probation violation complaints, I will set your case or cases for further proceedings after today. I'll set it for a final revocation hearing, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, and today you have the right to a reasonable bond. So with respect to each of these probation complaints, Mr. Vickery, you have two plea options. You can either plead guilty or not guilty. If you plead guilty, that is a complete admission by you to the complaint filed. If you plead guilty or completely admit to the complaint, the court will find you guilty and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the complaint filed, and as I said earlier, if you plead not guilty, I'll set your case or cases for a final revocation hearing in the near future, and I'll set a bond. Mr. Vickery, do you have any questions whatsoever regarding the rights or the plea options I've just explained to you?
No, sir.
Okay, we're going to start with the probation violation complaint. They were all...
No. Or at least they shortened it. That took forever. It did. All right. But I wanted to keep that in there on purpose. Because the judge is by the book, by everything except for this one thing that's coming up. See if you guys catch it.
Filed on January 8th, 2025. With respect to the first case, this is the receiving stolen property case in 24 CRB 348. How do you plead to the probation violation complaint in that case?
Guilty.
In 24 CRB 268, this is where you've been convicted of 2 counts of theft on September 9th, 2024. How do you plead to the probation violation complaints in those cases, or in the complaint in that case?
Guilty.
To the probation violation complaint filed against you in 24 CRB 267, this is where you were convicted of 1 count of theft on September 9th, 2024. How do you plead to the probation violation complaint in that case?
Guilty.
To the probation violation complaint filed against you in 24 CRB 251, where you were convicted of criminal trespass, a 4th-degree misdemeanor on August 15, 2024. How do you plead to the complaint filed against you in that case?
Guilty.
Finally, with respect to 24 CRB 213, where you were convicted of littering on September 9, 2024, that is a first-degree misdemeanor. How do you plead to the probation violation complaint filed against you in that case?
Guilty.
Do you understand, Mr. Vickery, by pleading guilty to these complaints, that you are waiving your right to a preliminary and final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify as well as not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to be proven guilty beyond a reasonable or by a preponderance of the evidence. All of those are hearing rights you'd be waiving by pleading guilty to these complaints. Are you sure you want to do that today?
Yes, sir.
You are also, by pleading guilty, waiving your right to an attorney. You do not have an attorney that is representing you or advising you at the current time. By pleading guilty, you would be waiving your right to an attorney. Is that what you want to do?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, sir.
Are you currently on probation, parole, community control, or post-release control with any other court?
No, sir.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to these complaints?
No, sir.
And are you thinking clearly and you understand everything that's happening?
Yes, sir.
Okay, I'm going to ask the corrections officer to provide you with 5 of the separate Form 5s. So one for each of the cases. They're Form 5. For the record, Mr. Vickery, do you read and write English?
Yes.
Now he's going to give you 5 of these forms, one for each of the cases. The form says all the same thing. Basically says, I understand that I have a right to a preliminary and final revocation hearing. At any hearing, I have the right to confront witnesses against me, to cross-examine witnesses, and to require the case be proven by a preponderance of the evidence. At my hearing, I could testify on my own behalf, but that I could not be compelled to do so, and that I could have witnesses testify on my behalf and have compulsory process for obtaining the presence of witnesses, that I have a right to an attorney and a right to a postponement to secure the services of an attorney, and that I am without funds to secure the service of an attorney, and the court finds this to be the fact. The fact, I have a right to have a court appoint an attorney to represent me without charge. I hereby waive these rights and submit the matter to the court. If you find those documents, all the same document, acceptable, you can sign the end date at the bottom of each of those 5 documents.
All right, real quick, in summary, this guy did a bunch of misdemeanors, bunch of kind of low-level misdemeanors. He didn't ask for an attorney. He didn't want a plea deal. He just pled straight up guilty to all of them. So he's in jail. He's like, I'm just going to take responsibility for it. I'm guilty. I'm guilty. I mean, that seems pretty straightforward. He's taking responsibility for what he's doing. He pled guilty. He's not fussing about it. All right. It's about to go down.
They've all been signed, sir.
Thank you. Thank you. The court finds that the defendant has executed in open court the 5 separate waiver of hearing rights and probation violation matters. Before I make a finding of guilt, Officer Benoit, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, officer, can you tell us, first off, your name, your position, and the nature of and the basis for these probation violation complaints?
I'm Sean Benoit, city probation officer. The basis of the complaints arise from him not maintaining contact with myself in my office through scheduled appointments, and he failed to comply with the treatment recommendations through community counseling. He had assessments complete while he was incarcerated the last time, had appointments scheduled that he failed to maintain, and that was about it, Your Honor.
Okay. The court finds probable cause exists for the filing of the complaints. I do find Mr. Vickery's pleas of guilty to be knowing, voluntary, and intelligent. As I said, I do accept the guilty pleas, and I will therefore find him guilty of violating his probation in each of these cases. Okay, Mr. Vickery, before I impose sentence, and you do face up to a maximum 507 days in jail, is there anything you would like to say?
No, sir.
Seriously?
Yes.
You don't have anything? You don't have anything to say, Mr. Vickery?
No, not at the moment.
I mean, this has been your mantra ever since we started seeing you, in the summer of last year. I mean, you just come into court, you admit to the complaints, you don't want an attorney, you just want me to sentence you. Do you want me to send you to jail for 507 days? Is that what you want?
No, sir.
Well, then tell me why! Tell me why I shouldn't send you to jail for 507 days. Speak up. Defend yourself. Say something. Help me to know what is going on in that head of yours.
Sir, I would love.
All right. I don't know if you guys notice what really bothers me about this. He has the absolute right to stay silent. He does not have to say anything. The way the judge just went off on him, forcing him to say something, that is against his Fifth Amendment right that he said. He said, I don't have anything to say, Your Honor. Nope. Sorry, Judge. Like, you can't do that. I like watching this judge because, he gets passionate about it. Like he's tired of seeing this guy, and I get it. But you can't force him to talk, and the judge yelling at the guy just forced him to talk. So now he's gonna say something. He doesn't have to, Judge. All right. That's my 2 cents. That's what really bothered me about this clip. Yeah. Judge is not right on this one. He's not.
I would like to become a productive member of the community. I've had trouble finding employment, and I've had trouble finding housing. And I had just recently obtained a phone to make contact with Mr. Vermont.
What was that last? What was that?
In contact with him.
What was that last part? I didn't hear that. I'm sorry.
I had just obtained a phone.
Unacceptable. 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 Not acceptable.
You mean the probation officer, Mr. Benoit?
Yes.
You mean to tell me you never knew how to reach him before just recently?
Not other than to walk into the courthouse.
Well, that's a lie. You want to stick by that statement? The last time you were in jail was not too long ago, and I know Mr. Benoit met with you and he gave you his contact information. Is that correct, officer?
You were at a car with the next appointment.
Yeah. You know where his office is. You know where the court is, right?
Yes, sir.
You ever make any attempt to come up here and to have communications with him, or do you wait for us to reach out to you?
No, I did not make any contact with him.
Okay. Did you ever follow up or follow through with anything that was required of you at the community counseling center after you were assessed in the jail the last time?
No, sir.
Why not?
No answer, sir.
You want to become a productive member of society, yet you don't follow through with anything. What's going on with you, Mr. Vickery? We've had this conversation before. You don't have much of a criminal history other than what's happened in the last year. So what's going on? Why all of a sudden are you doing what you're doing and you don't seem to care?
I just don't know what to say, Your Honor.
Okay, Officer Benoit, any positions?
No, Your Honor, I do believe that he does have a desire to change, and given opportunities, I would hope that he would take those opportunities if he was presented with one.
Okay, Mr. Vickery, I want to hear it from you. I want to hear it from you. And I shouldn't be begging you to tell me that you want help. You understand that?
Yes.
I mean, if you really wanted help, Mr. Vickery, you would be on your hands and knees asking me for help. But instead, you just say, well, I don't really have anything to say. So, I'm giving you this opportunity, Mr. Vickery, to tell me what you would like the court to do.
I would like help, sir.
What kind of help, Mr. Vickery?
Help with rehab, help with employment, help with housing.
And we've offered you help, perhaps not as intensive as what help we could provide you, but we have provided help for you in the past. Why haven't you, why should I say, or why should I be thinking that today is any different than the past? Probation officer is there to assist you, to insist, because I've ordered you in the past to obtain and maintain employment. I've ordered you in the past to get an assessment and to follow through with any recommended course of treatment. The probation officer is there to assist, to help you improve your life. So help me understand why now is different than the past times when we've offered you that assistance.
Your Honor, I don't want to spend any more time in jail. I would love to spend time with my kids, and I would love to just get back to normal. I apologize for not following through with the assessment and everything before. I will do this time.
Okay. So before this hearing, I had Officer Benoit and our bailiff meet with you. So Officer Benoit, did you happen to talk to Mr. Vickery about renewal court?
Yes, Your Honor, I did talk to Mr. Vickery about renewal court. I let him know about the program, the intensity of the program, what is expected of him, what it provides him. Mr. Vickery did accept and fill out an application for that specialty docket, Your Honor.
Okay, Mr. Vickery, renewal court is an intensive supervision program. As Officer Benoit, I'm sure, has explained to you, it's intense. But if you really want to change your life, and based on what Officer Benoit has indicated, you've actually signed an application to be part of that program, there's a lot going to be required of you. Are you ready for that intensity, that very intense supervision that will come with that program to help you change your life?
Yes, sir.
You do have that application?
Yes, Your Honor.
Okay. Okay, here's what I'm gonna do. He was arrested on February 26th, right?
Yes, Your Honor.
So he's entitled to 2 days jail credit. February 26th to today's date, February 28th. In 24 CRB 348, this is the receiving stolen property case. I'm imposing a jail sentence of 15 actual days in jail. So 180 days, total sentence 150 days, suspended. I will give him 2 days jail credit, which means he has to serve for an additional 13 days. That will give, I believe, the agencies time to conduct another assessment on him, because I'm sure they're going to need to assess him again for all the screenings to be done.
Now, I think the judge was. I know why he was passionate about getting the defendant to talk. He didn't want to sentence him to 500 days in jail. He still can't force him to talk, though. You can't do that. But yeah, no, I completely understand why, and he's trying to help him. I get that, and good for the judge for doing it. But from my understanding, again, I'm not a lawyer, but the judge can't force a defendant to speak if he says no. That's all I'm saying. That's all I'm saying. Not the why and how it ended up. Just that one point is all I was trying to point at.
Done for renewal court purposes. I'm going to extend his probation for 1 year. I'm ordering him to obtain a comprehensive diagnostic assessment with the Lake Area Recovery Center. And Community Counseling Center. And to comply with any recommended course of treatment. He's to remain drug and alcohol free, and all the other conditions of his probation that are already in place will continue. I will order him to successfully participate in and complete renewal court if he's determined to be eligible. In case number 24 CRB 268, and I'll start with 268A. That's the first conviction of theft. I'll give him. This is consecutive, so I'm going to suspend all 171 days in jail in subcase A as well as subcase B, so there won't be any actual jail time. I'm extending his probation for 1 year. Comprehensive diagnostic assessment at LARC and Community Counseling Center. Successfully participate in and complete renewal court if determined eligible. And I'm going to stop right here because I'm going to keep going, but I want to just say something, Mr. Vickery. Part of that recommendation may be that you have to go into residential treatment, meaning that you're going to go to live somewhere to help assist you with your treatment. I want to make sure that I'm not the experts. They're the ones who are going to determine whether you qualify for residential treatment or not. But I want to make sure, Mr. Vickery, that you're on board with that.
Yes, sir.
Okay. 24 CRB 267. This is the conviction of theft. Again, 171 days will continue to be suspended. I'm extending his probation 2 years, or 1 year, for a total of 3 years. And if I misspoke, I want to make sure. All of these probation will be extended for 1 year. Lake Area Recovery Center and Community Counseling Center assessment, comprehensive diagnostic assessment, successfully participated in and complete.
Yeah, I'm not upset that the judge was yelling. That I have no problem with the judge yelling. I like the judge. I like judges that get passionate like that. That's one of the reasons why I watch him, is how passionate he gets about his job. And yeah, I like that for him. Again, the only thing that I was pointing at was when he said the defendant said he didn't have anything to say, and judge says you're going to say something. That's the only thing. That's it. I don't care about the tone at all. Like, that's fine. He can yell all day long. I was entertained by that. So it has nothing to do with the tone for me pointing out the issue I have. But some of you, comments are on both sides. It happens. We don't have to always agree on things.
Renewal court if determined eligible. Now, all three of those sentences in 24 CRB 348, 24 CRB 268, and 24 CRB 267 are consecutive. And that's the most I can sentence him to. The other cases, 24 CRB 251, criminal trespass, I'm going to order the same things, but I'm suspended.
I think he gets like 2 weeks in jail, and then he's transferred to inpatient. So he's getting the help that he asked for. But yeah, he's got to spend 2 weeks in jail before transferred there.
Spending 29 days, but that sentence is concurrent. I'm extending his probation from 1 year up to, from originally 1 year up to 2 years. So I'm extending it to 1 year. All the same conditions: comprehensive diagnostic assessment at LARC and Community Counseling Center, successfully participating in complete renewal court if deemed eligible. The same applies to littering in 24 CRB 213. 171 days will be suspended concurrent to all other sentences, extending his probation 1 year. Comprehensive diagnostic assessment at Lake Area Recovery Center and Community Counseling Center, and successfully participate in and complete renewal court if deemed eligible. So you're going to sit there for a couple weeks, Mr. Vickery, and we're going to get you assessed while you're in jail. If by chance we receive assessments and completed screenings before your 13 days, the balance of your 13 days of sentence happens, I may release you early, and especially if it's directly into a residential treatment program. So we're going to try to get those assessments scheduled as soon as possible. And then if by chance, Mr. Vickery, you are found to be eligible for renewal court, I will conduct one more hearing to welcome you into that program. And so right now it's up in the air. We don't know whether you're going to participate in or not. It all depends on those screenings. So do you understand all of that, Mr. Vickery?
Yes, sir.
You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided you necessary to file an appeal without cost. And you have a right to have a notice of appeal timely filed on your behalf. Mr. Vickery, do you have any questions whatsoever?
No, sir.
Officer Benoit, anything?
No, Your Honor.
Okay, this matter is concluded.
I cut it off really quickly there. All right, that's it. I don't know if you guys noticed, but that's my outro. That means the show's over. Thank you guys so much for hanging out with me tonight. I appreciate it. You are awesome. You all are awesome. Yeah, it's after 9 o'clock. Words stop working. Thank you guys so much for the super chats, and the gifted memberships. You guys are awesome. I say awesome way too many times. I need to come up with a second word that's not just awesome. That would be awesome, wouldn't it? All right. I've got us set up to raid KCC. We've raided Lone Wolf all week. It literally all week we've raided Lone Wolf. So KCC's live. We're gonna raid her. Lone Wolf is live. So if you want to go over there, that's totally fine. But we are going to KCC. So make sure you tell her that I said hello. And it's Friday. That means tomorrow night's date night. No stream tomorrow night. So I will see you guys on Sunday night. You guys are awesome. Jeez, I really do need to come up with a new word. All right. Until next time, bye.